Hello, my name is Ide Dijkstal. This is a lecture for the International Bar Association lecture series, which brings an international perspective on trying war crimes domestically. In this lecture, I will address trials in absentia. To start, let me take a moment to introduce myself and my practice. I'm a barrister at 33 Bedford Row Chambers in London, and I'm also a US attorney. I have over 13 years of experience practicing in the areas of international criminal law and international human rights law, and also have experience in domestic criminal law. I have represented victims, accused persons, and government interests before international criminal tribunals, such as the International Criminal Court, Special Court for Sierra Leone, and the International Criminal Tribunal for the former Yugoslavia, and particularly for victims before human rights venues like the United Nations, European Court on Human Rights, and the African Court and African Commission. Now, for the topic of trials in absentia, this lecture centers on in absentia trials for war crimes, which are allowed under Article 323 of the Criminal Procedure Code of Ukraine, which provides that the court hearing in criminal proceedings as to crimes specified in Part 2 of Article 1 of this code may be held in absentia, without the accused who hides from the investigation and judicial bodies with the view of avoiding criminal liability. The provision clarifies that this only applies to accused who are adults and not to children. The lecture aims to consider the lessons learned during in absentia proceedings before international courts, which might assist in conducting such proceedings domestically and ensuring they are done in a fair manner for all parties involved, and particularly the accused not in attendance. Given that trials in absentia are allowed under the Criminal Procedure Code of Ukraine, this lecture will also review the purpose and justifications for conducting a trial in absentia, but also the conditions under which an in absentia proceedings are allowed. This lecture will review how in absentia trials have been approached by international criminal courts trying individuals for war crimes and crimes against humanity with a recognition and adherence to the applicable human rights standards. Therefore, it will be helpful to review what Ukraine's human rights obligations are to individuals of a crime, particularly, and individuals also who are being tried for a crime, particularly what fair trial and due process rights are required in Ukraine under international human rights law. I will also review human rights jurisprudence on in absentia trials, and importantly, the safeguards which are required to ensure that in absentia proceedings are conducted in a manner which fully respects the rights of the accused and therefore preserves the integrity of the legal proceedings for all parties involved. It is hoped that this discussion will highlight why it's important for all parties to the proceedings, and especially appointed defense counsel, to question all aspects of the proceedings to ensure that their safeguards and fair trial rights are taken into account. I'll start with a short review of how in absentia trials have been approached before international criminal tribunals. Under modern international criminal law jurisprudence, the trial of Martin Bormann before the Nuremberg Tribunal is often viewed as among the first proceedings to be conducted in absentia, but it was also remembered for the lack of evidence presented during the trial, and that the death sentence that was handed down at the end of the proceedings was issued despite evidence indicating Bormann might already be dead. The international criminal tribunals, which followed in the early to mid-90s, the International Criminal Court for the former Yugoslavia, the ICTY, and the International Criminal Court for Rwanda, the ICTR, took a more cautious approach to in absentia proceedings, which allowed some scope for such proceedings without the accused. For example, Before the ICTY, Rule 80 of the Rules of Procedure and Evidence allowed for proceedings in the absence of the accused if the individual is persistently disruptive. And under Rule 61, it's possible for the judge who confirmed the indictment to invite the prosecutor to present the indictment and any supporting evidence, which could include live evidence, to the trial chamber without the accused present for their determination of whether there is a reasonable basis to believe the accused committed the crimes charged. Rule 61 was used in the Mladic and Karadzic cases, given that the accused were at large for a lengthy period of time. A similar rule also exists at the ICTR. Before the extraordinary chambers in the courts of Cambodia, the ECCC, it is allowed that following an initial appearance and after being duly summoned to a subsequent hearing, if the accused continues to refuse or fails to attend the proceedings, or is expelled from them due to an infraction of the court's rules, then proceedings may continue in his or her absence, but with the attendance of the accused lawyers. The Special Court for Sierra Leone, the SCSL, follows a similar rule also. At the International Criminal Court, there is no provision in the court's founding documents for trials in absentia. And until recently, the only example of proceedings being conducted in the absence of the accused were the trials concerning Kenya, when accused President Kenyatta and Vice President Ruto requested that the court allow their absence from some proceedings, and this was granted by the court. However, very recently, the prosecutor of the ICC requested for the first time that confirmation of charges proceedings are conducted in the absence of the accused, specifically for the charges set out in the 2005 indictment of Joseph Kony. While the pretrial chamber has not made a decision on whether to authorize these proceedings in absentia, the prosecutor argued that Kony has evaded judicial proceedings for more than 17 years while the court attempted to locate him. If granted by the ICC, this would represent the first time that the ICC has conducted in absentia proceedings because of the inability to locate the accused or the accused's refusal to cooperate with the court. Last is the Special Court for Lebanon, which exemplifies the use of in absentia proceedings before international criminal tribunals. In its first completed trial, which began in January 2014, the court tried 4 individuals in the Ayash et al. Case who were not located and failed to appear before the court. The trial proceedings, which ended last year, convicted 1 of the 4 individuals at trial, acquitting the 3 others, and on appeal overturned the acquittal of 2 of the other accused. This procedure departed from the more conditioned and limited approach of other courts noted before, which allowed for some in absentia proceedings only after the accused person made an initial appearance before the court and therefore thereafter refused to appear. At the STL under Article 22 of its statute, in absentia proceedings can be conducted under 3 circumstances. First, when the accused expressly waives the right to be present. Second, when the accused is not handed over to the STL by the state authorities. And third, when the accused has absconded or cannot be found after reasonable steps have been taken. The trial chamber clarified the tribunal's power to conduct in absentia proceedings in a decision which noted that this third justification under Article 22, that the accused has absconded or cannot be found, means that there might be instances where the accused might not consciously evade the proceedings and when the accused is not aware of the proceedings. With this, I think it's relevant and important to consider the justification and rationale for moving forward with proceedings. and especially a trial in absentia. It is critical that conducting an in absentia trial is used as a last resort when alternatives would when the alternative would be that no proceeding can take place and none of the aims of the trial can be achieved. Therefore, the reason for in absentia proceedings is rooted in an understanding of the underlying reasons and aims of war crimes trials. The most outstanding and salient reasons for a trial is to determine the criminal responsibility of an individual for the crimes charged. With this comes the goal of accountability through punitive measures or punishment if the individual is found guilty. However, before international criminal tribunals adjudicating international crimes such as war crimes, other goals have also been discussed and raised. This includes, for example, creating a historical record of the acts committed, which includes all of the circumstances surrounding the perpetration of the crime, allowing the victims and even witnesses to tell their stories and accounts, providing the victims with access to the truth of what happened and potentially compensation if guilt is found, promoting reconciliation among the impacted communities, and creating a sense of deterrence for similar criminal actions in the future. While the guiding goal of a trial should remain focused on the determination of the guilt or innocence of the individual who is charged, parties to the proceedings and those observing trials and studying these trials have raised these other goals and aims as important and as consequences resulting from the proceedings. It is something that should be taken into account when considering in absentia trials. In absentia proceedings can also be viewed through these goals. When the accused evades or avoids a criminal process, conducting the trial in absentia serves the goal of getting resolution on the criminal responsibility of the accused based on the available evidence. But it does not allow the punishment issued if guilt is found to be carried out. The in absentia proceedings do, however, work towards the alternative aims of a trial, so that finding on criminal responsibility might allow the victims to pursue compensation after proceedings. It might allow victims to tell their stories, and it could work towards deterrence as well. It is notable that in the example from the Mladic and Karadzic cases before the ICTY, which I noted before, in absentia proceedings were used under Article 61, with one argument being that because of the long period of time since the accused's indictment, it was in the interest of the public to conduct the in absentia proceedings to hear the evidence which supported the prosecutor's charges. The proceedings could also be seen to reveal the truth for the victims or to create a historical record, but it must also be recognized that the truth and a full historical record will be more limited and will be incomplete without submissions provided by the accused person. It highlights the foundational importance of having the participation of the accused in order to fully understand all circumstances which led to the perpetration of the crime, or at a minimum, ensure that the absent accused has counsel acting on his or her behalf. This leads to looking at international human rights standards, which impact both a decision to conduct in absentia proceedings and how in absentia proceedings are conducted when allowed. Much of the hesitation by international criminal courts to fully embrace in absentia proceedings comes from concern about whether these proceedings are compatible with international human rights standards. The issue of whether there is compatibility between fair trial and due process rights and in absentia proceedings is approached through the lens of applicable human rights and addressing the safeguards required to conduct an in absentia trial in a manner which respects these rights. What is relevant to examine are the fundamental fair trial rights, which are considered universal, and also those human rights standards which Ukraine has explicitly accepted and agreed to guarantee. The government of Ukraine is party to several international human rights treaties and instruments, which provide protections to accused persons, which the government must guarantee. Key among these, when considering fair trial rights, is the International Covenant on Civil and Political Rights, for which Ukraine signed in 1986 and ratified in 1987, and which provides that an accused person has the right to be tried in his presence. In addition, the authorities in Ukraine must respect the rights and protections set out in the Universal Declaration of Human Rights as adopted by the General Assembly in December 1948. The authorities in Ukraine are also obligated to follow the guidance that's set out in the UN Minimum Standard Rules for the treatment of prisoners, also known as the Mandela Rules. These rules were agreed before the General Assembly of the UN and are considered universally accepted as essential principles for the treatment of prisoners. But they also contain principles concerning fair trial rights, which are foundational to any accused person being tried by the government of Ukraine or any other government, whether they're present or not. Similar to these international human rights standards is Article 7, the fundamentals of criminal proceedings under the Criminal Procedure Code of Ukraine, which raises such rights as equality before the law, human dignity, the presumption of innocence, freedom from self-incrimination, the right to a defense, adversarial proceedings, the ability to challenge decisions, and a reasonable time for proceedings, just to name a few of the rights that are listed under Article 7. In echoing many of the fair trial rights set out under international human rights law, Article 7 of the Criminal Procedure Code of Ukraine specifically states that proceedings in the absence of the accused must adhere to these fundamentals. From these human rights obligations, both the international ones and the domestic ones that I have reviewed, and from jurisprudence from human rights bodies, 3 safeguards have emerged as critical to preserving an individual's fair trial rights when in absentia proceedings are utilized. This includes, first, providing sufficient notice of the proceedings to the accused person so that they are aware of those proceedings. Second, providing the absent accused person with defense counsel and the ability to be effectively defended and represented. And third, the right to a retrial if the individual appears before the court at a later date. I'll address each of these safeguards now and the relevant fair trial rights and human rights jurisprudence which supports each of them. I'll start with the safeguard of sufficient notice. Human rights jurisprudence from both the Human Rights Committee and the European Court of Human Rights have specifically raised notification of the accused as critical to protecting their rights during in absentia proceedings. To start with the Human Rights Committee, this is the body which monitors the implementation of the rights within the ICCPR, for which you'll recall Ukraine is a signatory. In monitoring states' adherence to the rights they agreed to protect, the committee can receive complaints from individuals who claim that the rights under the ICCPR have been violated, and the committee can make findings on whether the alleged rights violations have occurred. It is good to note here that Ukraine has not only signed the ICCPR, and agreed to protect the rights that are within it. But it has also accepted the optional protocol of the ICCPR, which allows for these individual complaints. Within this context, the Human Rights Committee addressed the requirement of notice, and I'll refer here to a case from 1990, the case of Manguya Mbenge versus Zaire, which was a case concerning an accused who was tried and sentenced to death in Zaire while living in Belgium, and only learned of the proceedings when the results were reported in the press. When examining whether the accused's rights under the ICCPR were violated due to Zaire's lack of notification, the committee first clarified that proceedings in the absence of the accused may in some circumstances be permissible in the interest of proper administration of justice. Given that protections in Article 14 cannot be construed to mean that in absentia proceedings are never allowed, especially when the accused person has been informed of the proceedings and declines to attend. The committee found that if all necessary steps had been taken to notify the accused of the proceedings, then this would impact a number of other fair trial rights set out in Article 14. I'm going to repeat the past paragraph. The committee found that if all necessary steps are not taken to notify the accused of the proceedings, then this would impact a number of other fair trial rights set out in Article 14, including, first, the right of defense through legal counsel. Second, the right to have adequate time and facilities for the preparation of a defense. Or third, the right to examine witnesses against the accused, or also to have witnesses called on the accused's behalf. The Human Rights Committee reflected this finding in its 2007 General Comment 32, which stated that in absentia trials are only compatible with Article 14 if the necessary steps are taken to summon accused persons in a timely manner and to inform them beforehand about the date and place of their trial and to request their attendance. Here, the burden is on the state to demonstrate that the accused person has actual knowledge and awareness of the proceedings. And the burden goes beyond regular due diligence, such as lodging the charges in a court registry, as was found by the European Court of Human Rights in the case of Colonza v. Italy. In the Human Rights Committee's case of Maliki versus Italy, it went so far as stating that it is incumbent on the court to present evidence which would verify that the accused would be aware of the proceedings. Therefore, additional steps, such as attempting to make the accused aware through publication in the press, goes towards finding that the state has met its burden of notification. This was used by the Special Tribunal for Lebanon, the STL, in the Prosecutor versus Aish case, whereby the trial chamber found that by publishing the indictment in the news, and particularly in Lebanese media outlets, awareness of proceedings would have been unavoidable to any person in Lebanon who was reasonably aware of current events, and particularly for the person named and directly concerned by that news. However, it is recalled that in the Manguya Mbenge versus Zaire case, the Human Rights Committee found that while steps to provide notice to the accused are required to ensure in absentia trials are consistent with human rights obligations, the committee also acknowledged that there must be certain limits to the efforts which can duly be expected of the authorities for establishing contact with the accused. The next safeguard to ensuring the in absentia proceedings are consistent with human rights obligations is to ensure effective legal representation is provided. Here again, I look to the provisions under human rights law for which Ukraine is obligated to follow, and note that the right of any person accused of a crime to legal representation is strongly provided. Article 14 of the ICCPR ensures this right, and the Human Rights Committee reiterated this protection in its General Comment 32. The Mandela Rules provide further support for this right by noting the requirement for ensuring and appointing legal counsel during detention and in preparation for legal proceedings. Referring again to the Human Rights Committee's decision in Mongoyo Mbenge versus Zaire, it is recalled that the committee found that because notification was not properly secured, that further Article 14 fair trial rights were impacted and violated. Here, I submit that the same logic applies. Should the right to counsel under Article 14 of the ICCPR not be protected during in absentia proceedings, then further rights listed under Article 14 would also be violated, compounding the harm to the accused's rights. For example, were an accused not to have legal representation during in absentia proceedings, then it could also be anticipated that the right under Article 14 to adequate time and facilities for the preparation of the accused's offense would also not be protected, as there would be no party to prepare or to present a defense on the accused's behalf. General Comment 32 provides details on the right to prepare a defense and clarifies that this includes access to the case file and other documents and evidence to be used in the proceedings, there again highlighting that the role of defense counsel is key to obtaining those documents and to analyzing those documents. It also includes any exculpatory material within the possession of the court, remembering that the right to be presumed innocent before proof of guilt is also a fundamental right under Article 14 and within the Universal Declaration. With exculpatory material in mind, the role of appointed defense counsel is important to present such evidence to the court as part of the defense case. The ICCPR notes that the nature and cause of the charges must be clear, highlighting the need for defense counsel to ensure that charges are sufficiently clear, that they're characterized and supported from an early pretrial stage to protect the defendant's rights from the start. Keeping in mind that jurisprudence from the UN Working Group on Arbitrary Detention indicates that when it evaluates whether fair trial rights are being maintained, it looks to whether the legal basis justifying the detention is accessible, understandable, non-retroactive, and applied in a consistent and predictable way to everyone equally, then it's applicable also, and it can be used in order to analyze the rights for in absentia trials. Although the situation for in absentia proceedings and trials does not regard an individual in detention as is analyzed by the UN Working Group on Arbitrary Detention, the evaluation of whether charges against an accused are understandable, are accessible, and are non-retroactive still has some applicability in understanding whether the accused's fair trial rights are being maintained in the early stages of the proceedings, and it's something that should be looked to as well. Another fair trial right under Article 14, which would be impacted if counsel were not appointed and able to effectively and thoroughly represent the accused, would be the right to examine witnesses. This includes cross-examination and confronting the witnesses called against the accused, and calling and examining witnesses on behalf of the defense. It is only through counsel's effective and thorough representation that evidence presented by the prosecution can be tested and that the court can hear evidence from the side of the defense as well, recalling again that some of the aims of war crimes trials are to provide an accurate historical record, which includes all circumstances surrounding the perpetration of the crime, something that wouldn't be possible without taking available steps to call evidence on behalf of the accused. To this, it's noted that in addressing these fundamental fair trial rights under Article 14, General Comment 32 also provides a warning to any evidence, including statements or confessions, and which are obtained through torture or through inhumane acts, through coercion or through force, as being in violation of the right against torture, which is also set out in the ICCPR under Article 7, but also under Article 5 of the Universal Declaration and within the Convention Against Torture, for which Ukraine has also accepted. The issue of evidence adduced by torture or forced confession is often thought of in regards to the accused, and it could still be in the context of our discussion here if the in absentia proceedings concerned an accused person who was in detention, had a statement taken, and only after absconded from the proceedings, and therefore in absentia proceedings took place after that point. However, if the situation is one where the accused has avoided or for any other reason never been in the custody of the authorities or appeared before the court, then this warning about protecting the evidence against for the right against torture could also be applicable to the witness evidence offered in the case against the absent accused. In addition to prohibiting torture and inhumane treatment, these protections also hold that evidence obtained by way of torture, abuse, force, or coercion should be excluded. And it's critical that defense counsel is vigilant to monitoring for such evidence, no matter where it comes from, in order to protect those rights of the accused. Overall, it's the thorough legal representation of the absent accused, and it's through this kind of representation that each of the fair trial rights required to find that a trial is in compliance with human rights standards can be achieved. It demonstrates the importance of defense counsel's role in not only protecting the accused's rights when both present and also when the accused is absent, but in protecting the integrity of the proceedings and the ability of the court to conduct a fair trial that's unbiased despite the accused's absence. The last of the three safeguards for ensuring that an in absentia trial is compliant with human rights standards is to guarantee that should the accused be located or appear at a later time before the court, that the accused is given the right to a retrial. This calls to mind the human right to an effective remedy, as noted under Article 8 of the Universal Declaration, which could be applicable to an individual who is trialed in absentia, but later appears before the court to seek a retrial. Jurisprudence from the Human Rights Committee approaches such a retrial as a trial of first instance, and the European Court of Human Rights views it as akin to appellate de novo review based on the facts. And with this in mind, it's important to fully test the evidence put forward by the prosecution, recalling the goals of a war crime trial and that part of its aims might be for victims to tell their story or to create a historical record. It must be considered that the proceedings which will be conducted in absentia will also function to help preserve the evidential record. What is presented during in absentia proceedings will create the evidentiary record, which could significantly impact the outcome of the retrial. Consider that evidence presented during in absentia proceedings, particularly live evidence from victims or witnesses might either not be available at a later time or could come against the reality that memory fades over time and contemporary evidence is often given more weight by a court. It is therefore important that this evidence is thoroughly tested and challenged by the defense when it is first available, but also when memory and recollection from that witness is at its strongest. This role by defense counsel could help ensure that evidence is not left on the record without any challenge or response being also recorded. With these rights and safeguards in mind, when preparing an absent client's defense, it should be noted that discussions by counsel for accused at various international criminal tribunals, and particularly the Special Tribunal for Lebanon, the STL, where in absentia proceedings were conducted. During these discussions with these counsel, it was raised that in order to maintain their independence from the court, it was important for counsel to determine for themselves the scope of their representation. Counsel also had the freedom to choose defense strategy, but took into keen consideration whether it was in the best interest of the client to raise certain arguments during the in absentia trial or reserve them for a potential retrial in the future. And in making these kind of strategy decisions, it's important to weigh how reserving any points of arguments for a later time might impact the overall outcome of the present procedures. But from what these counsel and what the discussions from these counsel has highlighted is that defense counsel should have the freedom and the independence to make these decisions for themselves in the best interest of their client. As a final note, I'd like to raise the perspective of the victims. Having myself represented victims before international tribunals and having also acted on the defense team for accused, I think that the perspective of victims in war crimes trials is helpful to this discussion. To start, it should be remembered that human rights, that the human rights that come into play for victims during criminal trials against an accused person include for the victims the rights to a remedy and the right to access to the truth. For many of the victims I have represented, they are not interested in seeing one-sided justice, which doesn't truly get to the bottom of what happened and doesn't provide the whole truth of the circumstances of the crime committed. Nor are the victims interested in proceedings which can be perceived as biased and which might not stand up to scrutiny on appeal. We have seen the example of acquittals before international courts, where, for example, in the Bemba case before the ICC, victims followed and participated in the proceedings for at least 10 years, only for the court to acquit Mr. Bemba on appeal. Many of the victims I work with recognize the importance of a robust defense, or come to understand this role better after outreach on why it is important. Because it is with careful protection of the accused rights that the truth can be best and most accurately understood. The outcome of the proceedings can be viewed as more secure under review on appeal, or if there is a retrial, and also so that the integrity of the proceedings and the court are preserved. And from my experience, many of the victims that I have worked with have these goals in mind and therefore understand the importance of a vigilant and thorough defense for the accused person, whether or not they are present for the proceedings. And it makes the defense counsel's role in preserving these rights when the accused is not present all the more vital. I'll end it there, and I hope this lecture has proved to be helpful in providing perspectives on handling in absentia proceedings. Thank you.